where both the parties to an agreement are under a mistake as to a matter of fact essential to the agreement is void. Explanation. An erroneous opinion as to the value of the thing which forms the subject matter of the agreement is not to be deemed a mistake as to a matter of fact. Illustrations. First, A agrees to sell to B a specific cargo of goods supposed to be on its way from England to Bombay. It turns out that before the day of the bargain, the ship conveying the cargo had been cast away and the goods lost. Neither party was aware of these facts. The agreement is void. Second, A agrees to buy from B a certain horse. It turns out that the horse was dead at the time of the bargain, though neither party was aware of the fact. The agreement is void. Third, A, being entitled to an estate for the life of B, agrees to sell it to C. B was dead at the time of agreement, but both parties were ignorant of the fact. The agreement is void. Different kinds of mistakes. Broadly speaking, there are two kinds of mistakes. First, mistake of fact, and second, mistake of law. Further, mistake of fact may be either bilateral or unilateral. The mistake of law may be, first, mistake of law of the land, and second, mistake of foreign law. Bilateral mistake. When both the parties to the agreement are under mistake of fact essential to the agreement, the mistake is called bilateral mistake and the agreement is void. Unilateral mistake. There is unilateral mistake where only one party to a contract is under a mistake as to a matter of fact. Generally speaking, such a contract is not invalid. Thus, where a person due to his own negligence or lack of reasonable care does not ascertain what he is contracting about, he must bear the consequences. Mistake of law. The mistake of law may be, first, mistake of law of the land, and second, mistake of foreign law. In the first case, the rule is ignorantia juris non excusat. It means ignorance of law is no excuse. A contract is not voidable because it was caused by a mistake as to any law in force in India. Thus, where A and B make a contract grounded on the erroneous belief that a particular debt is barred by the Limitation Act, the contract is not voidable. Further, a mistake as to law not in India has the same effect as a mistake of fact. Ignorance of law is no excuse, is incapable to foreign law. The mistake of foreign law is to be treated as a mistake of fact. Consequences of mistake on contracts. Mistake renders the contract void as such in case of a contract which is yet to be performed. The party complaining the mistake may be repudiated, that is, need not perform it. If the contract is executed, the party who received any advantage must return it or make compensation for it as soon as the contract is discovered to be void.